An ad hoc press release regarding a company's intention to acquire or merge with another company is a formal statement issued to the public and relevant stakeholders, including shareholders, investors, employees, and regulatory bodies. This press release serves to inform the public about significant developments within the company that may impact its operations, financial status, or strategic direction. Legal obligations associated with such announcements can vary significantly from country to country and may depend on the regulatory framework governing mergers and acquisitions in each jurisdiction. However, there are some common legal obligations that companies typically need to comply with when making such announcements. Legal obligations. Disclosure requirements. Companies are often required to disclose material information regarding mergers or acquisitions in a timely manner to ensure transparency and fairness in the financial markets. This typically involves issuing a press release or filing regulatory documents with relevant authorities such as the Securities and Exchange Commission, SEC in the United States, or the Financial Conduct Authority, FCA in the United Kingdom. Regulatory approvals. Depending on the jurisdictions involved and the nature of the transaction, companies may need to obtain regulatory approvals from government agencies or antitrust authorities. Failure to secure necessary approvals can lead to legal challenges and may ultimately derail the transaction. Shareholder approval. In many cases, companies are required to seek approval from their shareholders before proceeding with a merger or acquisition. Shareholder approval may be obtained through a vote at a general meeting or by soliciting consent through proxy statements. Disclosure of material risks and synergies. Companies are typically required to disclose material risks and potential synergies associated with the proposed transaction. This information helps stakeholders make informed decisions about the transaction's implications for the company's future performance and value. Compliance with insider trading laws is crucial for companies and their executives when making announcements about mergers or acquisitions. This includes refraining from trading securities based on non-public information and ensuring that all material information is disclosed to the public in a fair and timely manner. Failure to comply with these legal obligations can have serious consequences, including regulatory sanctions lawsuits from shareholders or competitors and damage to the company's reputation. There have been numerous examples of companies facing legal challenges or regulatory scrutiny due to alleged violations of disclosure requirements or antitrust laws in connection with mergers and acquisitions. Some of the examples include the 2016 legal challenge faced by telecommunications giant AT&T from the US Department of Justice over its proposed acquisition of Time Warner. The DOJ sued to block the merger, alleging that it would harm competition in the media industry. After a protracted legal battle, AT&T ultimately prevailed and completed the acquisition, but the case highlighted the regulatory risks associated with large-scale mergers. Similarly, in 2018, the proposed merger between healthcare companies Cigna and Anthem was blocked by a federal judge after the Department of Justice raised concerns about its potential negative impact on competition. The failed merger resulted in significant legal costs for both companies and underscored the importance of thorough antitrust scrutiny in merger transactions. Companies planning to acquire or merge with another company must carefully navigate a complex legal and regulatory landscape to ensure compliance with applicable laws and regulations. Failure to fulfill legal obligations can have serious consequences, highlighting the importance of comprehensive due diligence and transparent communication with stakeholders throughout the transaction process.